Hello everyone, this is Gaston from Markman Advisors with this week's Markman Minute. You can catch all of our content on a weekly basis at mimesis.law.com, where we post these minutes talking about interesting stories of interest to investors with respect to patent litigation events. So for this week's discussion, I wanted to focus on a very interesting case that really proves the old adage is true, that timing is everything. The situation involved a multinational software company, SAP, which is one of the largest in the world, who was attacked back in 2007 with a patent infringement claim by a privately held company called Versata. That case made its way through the court system. The case was filed in the Eastern District of Texas and ultimately culminated in a pretty large verdict by patent standards that by the time the case in the district court was done with interest and all the other penalties tacked on, added up to $391 million. So not an insignificant amount of money, and clearly catapulting Versata's patents into the ranks of one of the most valuable of all time, to be honest. Fast forward a little bit to 2013. After the district court case wrapped itself up in 2011, SAP obviously appealed the decision to the Federal Circuit, which is the appeals court that oversees all patent cases. We've talked a lot about that court and its importance in the past. And SAP brought the full gamut of issues in front of the Federal Circuit, arguing that it should not have been required to pay that large judgment. Unfortunately for SAP, they lost in the Federal Circuit, and as a result, the parties entered into a confidential settlement after the Federal Circuit decision came down in 2013. Now, we can only imagine what that settlement was for, but considering the leverage that Versata had over SAP at that point, one must imagine that they collected some serious cash based off the $391 million verdict that they had in hand. What makes this case particularly interesting, other than the fact that these are big numbers for a patent case and can serve as a poster child for how valuable a patent could be, is that SAP also initiated in 2013, in parallel with its appeal, a challenge to the validity of the patent utilizing what was then the new American Invents Act. And in particular, the ability to file what's called a covered business method or CBM review of Versata's patent, which is exactly what SAP did. They took advantage of the change in the law that came through the American Invents Act and went ahead, because the judgment against it was not yet final on appeal, went ahead and tried to get Versata's patent invalidated under this new regime that has been created in the patent office. That process went ahead, and in fact, the decision by the Patent Trial and Appeal Board, which oversees these CBMs, in the Versata case was actually the first written final decision in any CBM proceeding. Interestingly, despite the fact that the patent had been litigated for years and had been found valid at the district court level, and that the district court verdict had been rubber stamped by the Federal Circuit, the initial determination of the Patent Trial and Appeal Board was that the patent was actually invalid, or more precisely, drawn to ineligible subject matter under Section 101 of the Patent Act. The argument is that Versata's invention is not something that should be patentable in the first place. And I think this brings into brings to the fore some of the issues that we've talked about in the past with respect to the Supreme Court's later in 2014 Alice decision, which really defined the contours of what should be patentable and what shouldn't be in the business method / software arts. So what we have here is a very interesting situation. Versata took advantage of a period of time where patent awards were high, and patent litigation was easy for patentees by filing their case in 2007 in one of the most friendly patent courts in the country, if not the friendliest, the Eastern District of Texas. They parlayed that effort into a jury verdict, which exceeded $350 million, and then were successfully able to get that verdict upheld on appeal. In contrast, SAP had to endure this entire process, which obviously was turning out very negative for them, until they were thrown a lifeline by the American Invents Act, and they filed this CBM. Now, this CBM, as we've stated, actually resulted in the fact that Versata's patent was canceled as being directed to ineligible subject matter. So what happened recently that really brought these issues into focus? Well, Versata appealed the Patent Trial and Appeal Board's determination that it never should have gotten its patent. And that appeal was just decided last week by the Federal Circuit. And guess what? The Federal Circuit decided that the Patent Trial and Appeal Board was right, that the patent was directed to ineligible subject matter, and that Versata never should have had a patent in the first place. So in the space of a couple of years and really tracking the development of the patent law and the pendulum shift from patent rights being valuable and having giving patentees a lot of options and potential value to the current regime, where it seems like defendants always win and patentees have a very hard time on collecting on their patent rights. This case in a microcosm really illustrates the depth and length of how far the pendulum is swung. For SAP, they're obviously pleased that they were able to get the patent invalidated and declared that never should have issued. But they wish that this process could have went a little bit differently, because if they had, they maybe wouldn't have had to pay any money to Versata in the settlement that was announced in 2013. So I think this is an interesting situation that really brings to the fore a lot of the elements that have been on the minds of people in the IP space lately, and that goes for patent owners, investors, and lawyers like myself. Things like what's patent eligible under the Alice decision. Things like, what's the role of the Federal Circuit in really policing both the district courts like the Eastern District of Texas and the PTAB with respect to these post-grant proceedings like CBMs and IPRs. It just shows that there's a lot of value still to be extracted from the IP process, and it's more important than ever for investors to make sure they have a full understanding of all the parallel proceedings and the timing of each. That's it for this week's Markman Minute. Again, my name is Gaston from Markman Advisors. You can check out all our content on MimesisLaw.com. See you next time.